Hi, I'm Jonathon Kappy.
And I'm Sanaya Mistry.
Welcome to Holland Estates. You're listening to episode number 613. Today we are going to be discussing passing of accounts and their scope. How you doing, Sanaya?
I'm doing well. How are you, Jonathon?
I'm good, COVID good, hanging out at home in all my glory.
Yep.
But things are good. Great weekend, weather was beautiful.
Absolutely. It's definitely starting to get warmer, which is really nice.
So today we want to talk about a decision which is Munro and Thomas, which is a passing of accounts case. And we see this a lot in our practice, and we think that this is a good example of things that we can share with the viewers in terms of sometimes the scope tries to get too big and how the courts may deal with them. So Sanaya, why don't you give us a bit of a rundown of the facts?
For sure. So in this case, the deceased had 4 children, one of which was the applicant. The estate trustee was the deceased's son-in-law, Thomas. In this case, the applicant brought this application to seek the respondent to provide full bank records, full medical records, submit to an examination under oath, submit to a cross-examination on the affidavit, and just a lot of things that you don't typically see in an application from a beneficiary of an estate. While the respondent had provided informal accounts of the estate, the applicant wasn't satisfied with the informal accounts that had been provided, and so brought this application. The court found that in this matter, the applicant was seeking much more than they were entitled to. The court found that the respondent had, provided all of the information that they should have. They administered and accounted for the estate in a full and complete manner, and left open the possibility for the respondent to bring an application to pass accounts, even though they did not have an issued certificate of appointment of estate trustee.
Right. So let's break this down for a second. Okay, so we've got a situation, we've got an estate that's being administered, okay? In this particular case, there was no probate, but that really didn't matter, okay? And it wasn't the applicant wasn't complaining about the assets that were being administered, right? The applicant was complaining about assets which the testator had disposed of well before she had passed away. And in particular, we're talking about a cottage and the primary residence.
Correct.
Okay? So she died in 2019, and I think it was in 2011 and 2013 that those two properties were disposed of. So we're not talking about the assets that the estate trustee actually administered. What this applicant was trying to go after was things that had been disposed of well before date of death. And the court heard a lot of evidence about capacity prior to death. And I was surprised by that, but the court really went through the analysis of, was this lady capable? She was living on her own. She was managing her own property. She was managing her own health. She did not require power of attorney at any point in time. And were these valid gifts made at the time, or there was any reason to suspect that these gifts were not valid gifts? And if they were valid gifts, they're not part of the estate. It is beyond the scope for the estate trustee to administer, right? I mean, that was really what the issue was.
Yes.
So, and I guess that comes up a lot, right? When you come in, and you'd even be brought up in the context of a passing, right? It's, well, where was this asset? And as an estate trustee, you're a fiduciary for the beneficiaries, and you have an obligation to bring in assets that are properly part of the estate. But sometimes you investigate, and it really, at least in your determination, is not part of the estate. And that's what this estate trustee did in this particular case. So, I mean, I think it's telling, and the facts are telling. I mean, you've got an applicant who was a daughter, who was one of 3 children, who admitted that she wasn't particularly close with her mother, who, as part of the will, got the smallest portion of any of the children. I think she got 10%. And you also have the cottage, which was gifted by mom to 2 of the kids.
Mm-hmm.
And the mom actually required that they make provision for the 3rd child, because I think it was worth around $100,000. So they said, you guys get it, but I want you to give $33,000 when I die to the 3rd child. And obviously this applicant was not part of that arrangement. But I do think that was a really big part of the judge's analysis in terms of, did she know what she was doing? Did she understand? Was it supposed to be part of the estate? And I think the judge came down to it and said, no, it's not. I mean, this is not even a PACOR situation. There was no joint tenancy. This was gifted. So
absolutely, it was definitely a gifted situation. And in PACOR, there's a resulting trust because of joint tenancy, and that's not the case here at all. And the fact that she did it so many years ago before she died and had a plan in place, that sort of is also very telling, right? With gifting it to two and then having them pay a certain amount of money to a third when she dies, like that shows that this was intentional and shows that a lot of thought sort of went into this.
Yeah, that's true. And I think it goes, and I think the other fact is that the primary residence was sold to an arm's length third party. So, I mean, there's not much you can do with that, So, and so at the end of the day, what did the judge say?
At the end of the day, the judge noted that the respondent had done his job and accounted for his administration to the full extent. And the judge also noted that the applicant's demands fell outside of the respondent's accounting obligations and fell outside of the applicant's rights as a beneficiary to the estate.
Yeah. So I think there's an interesting quote from the judge. It said, in referring to passing of accounts and accounting obligations, the court said it should not be made an instrument of potential abuse of a party arising from the hostility, suspicion, or paranoia of another party. So you may be a residual beneficiary. It doesn't give you unlimited ability to wreak havoc on the estate trustee. So, listen, the judge did open the door for the estate trustee to ultimately pass his accounts if he wants. She said, well, you haven't got probate, but I'll let you pass. I don't think that having probate is a prerequisite for being able to pass your accounts. I think there's case on that, and Paul blogged on that. And so if you're looking for a case reference on that, go look at Paul's blog. So yeah, you don't need probate in order to pass. But we were talking offline before this, and I think we both agreed that it's possible that the estate trustee would want to pass it just because it's not likely this applicant's going to give a release. But I think it's arguable that this decision in and of itself makes the determination that the accounting was complete and proper, even if there is no judgment on passing, and res judicata may likely apply. So an interesting case dealing with scope. It comes up a lot, and we just thought it would be a good one to share. So that concludes our podcast. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Sanaya Mistry.
Should you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Have a great day.
Thank you.